Judges don't know how to recognize junk science from real science. We intend to use this report to educate the judge in this case.
If anyone's thinking this is going to be an easy slam dunk case, they're far from mistaken. Far from mistaken.
This is a case of forensics at the end of the day. There are no witnesses. There are no, it looks like, am I correct that this case appears to be, from all the evidence that the state has presented to you, this is going to be a case of forensics?
You're 100% correct, Kerry. And whenever you have a case where there's no confession, there's no eyewitnesses, and there's no nuclear DNA at issue here, you're relying on forensics, which makes this report all that more important and all that more relevant.
So, Linda, if this does boil down to a case of forensics, and as Jose just said about this report, I would never want to suggest that you'll say confidence, but do you believe that the state has the smoking gun evidence? I mean, obviously you're going to defend your client to the fullest. Have you seen anything here that is going to require heavy interpretation for the defense to actually show that she is not responsible? Or, because I'm looking at stuff that says tape that is similar from the same sort of role. All just sort of like verbiage that appears to be generally suggestive as opposed to conclusive.
Right. Well, they cannot have a smoking gun because the client is innocent, and we truly believe that. But you see that when you look at these reports. If you recall, there were reports that there were fingerprints, that there was a heart tape sticker on the duct tape. These reports say otherwise. And when they try to link Casey in some way, they don't do it scientifically. They say similar, could be, possibly, and that is not science.
Let me read your exact quote here, Linda. It says, the duct tape pieces, and these are the pieces found at the scene as well as the pieces found on the gas can. The duct tape pieces originated from the same source roll of tape or from rolls of tape manufactured in the same manner. Well, this sounds pretty broad to me. I mean, do you think that, if you went to other neighbors in the neighborhood, you could find other types of pieces of duct tape that is also, I assume everybody goes to Home Depot.
It is broad because Henkel's, which is in the report, is one of the largest manufacturers of duct tape in the United States. And not only that, it's that kind of broad science when they say it looks similar, could be similar, has the same physical composition that the FBI used in other analysis, such as bullet lead analysis. Now they're trying it here. It didn't work there, and it won't work here because it's not real science.
All right. What is this study suggesting about the difference between real science and junk science and what's being presented in the courtroom?
Well, this report clearly says that the only science in the courtroom that is truly accurate right now is nuclear and maybe mitochondrial DNA, but it's DNA. All other sciences that are relying upon a person, a examiner, an analyst, to look at items, compare them, is filled with bias, is subjective, and is filled with taint, where people try to taint their testimony or taint the science to fit the bill of a conviction. The only type of good science right now is DNA. All other science are subject to bias, they're subjective, and they're junk science put out by junk scientists. Judges don't know how to recognize junk science from real science. We intend to use this report to educate the judge in this case.
Have a look at some video here. Jose Baez and Macaluso finishing the last deposition of the day just 20 minutes ago. Deputy Gerald White told them that when he took a tip from Roy Kronk back in August, he handed it to Yuri Melich, lead detective in this case. Melich allegedly told him the area had been searched with deputies and dogs. This defense team is convinced Kaylee's remains weren't in those woods until after Casey went to jail.
Keo Marie Cruz is the woman who told law enforcement that she and Casey used to hang out in that same wooded area where Kaylee's remains were later found. Casey also reportedly told her that Cindy would not allow her to give Kaylee up for adoption.
It's garbage.
Is it your information that this woman sold her story to a tabloid?
Well, we're going to find that out. That's certainly something we're going to inquire about. It really only affects someone's credibility if they change their story or dramatize it a little bit. We have gained a wealth of information these last several days that we did not have before. certain insight, and we confirmed a lot of things that we suspected.
It must not be easy being friends with Casey Anthony. Sooner or later, you know you're going to get in the hot seat. Today, Casey's childhood friend, Kio Marie Torres Cruz, gave her deposition in the case. She is the one who said that she offered to adopt Kaylee before she was born. She sold her story to the National Enquirer, and she told the tabloid she and Casey used to bury their childhood pets in the same woods where Kaylee's body was found.
It's garbage. It's garbage. When there's a financial motive for your story and you've sold it to a rag like the Enquirer, I don't think it does anything for anybody's credibility.
Today, they were talking Roy Kronk. He's the former meter reader who found Kaylee's remains. The defense started the day questioning under oath a co-worker, and then finished off in the hot seat was an Orange County Sheriff's investigator. Now, Kronk found the child's body in December, but phoned a tip in months before. Jose Baez presumably wants to understand what happened that first time around. He says that he wants to make sure law enforcement did everything right.
Why law enforcement behaved in the way they did and why this case was investigated that way, and in hopes that if a more thorough job had been done specifically with those, we believe that there could have been something that might have helped exonerate our clients.
The hairs that you mentioned there today, that Dr. Henry Lee, why is that important and what does it tell you?
I'm going to turn it over to Linda now so she can answer the forensic questions.
Okay. Well, it tells us that the car was not completely processed at the time that it was allegedly processed by the law enforcement, with all the implications that that entails, and we intend to get into that at trial. That's one of the reasons why we asked for bench notes, handwritten notes, because the normal practice is when you take a process scene, you write down what you process, and then you hold on to those handwritten notes. They are called bench notes. And you know, this is a process of education. We have to educate the judge who may never have come across this, and we're not going to back down. We're going to keep, and we're going to get the stuff. Eventually we're going to get the stuff, because every scientist, I'll guarantee you, even from the prosecution side who will testify, will say it's standard practice to take bench notes. And anyone who objects to getting bench notes are going to find that the scientists are going to say, that's what's in a file, that's what's required, that's what's required when we have what's called an accredited laboratory, and so eventually we're going to get them, and it's just a process of education. Many attorneys, if you read the National Academy of Science reports, don't even know they exist. Many attorneys don't know what a bench note is. Many judges don't know what a bench note is. So I think that's the situation. It's not usual. People don't understand it, and then, as I said, it's a process of education.
Why didn't you ask for them? Why didn't you just ask for them? Does it suggest if they found, if Dr. Lee found 17 hairs, that there was sloppy work done by the county?
Well, it has that implication, or it could have other implications, and we'll see when we cross-examine a trial. Somebody over here?
Why didn't you ask for the DNA bench notes? The judge is telling you just to simply ask for them. Why didn't you?
We have. The prosecutor had indicated that we were.
Why didn't you ask the FBI for them was my question.
Excuse me, I'm answering your question. Let's do one. Okay. We did ask for them.
I didn't ask a clear question.
Okay.
Why didn't you ask the FBI
Well, let's do the first one. We did ask for them. We didn't get it. The second thing is the FBI does not give them to us. They give them to them. We don't want them to give them necessarily to them. We want to give them to us.
Why didn't you ask for them?
Because I have. Because
I don't understand your answer.
I don't think I understand your question, but you have to understand is we have talked to the FBI. I talked to the FBI on a number of cases.
And they said no, they weren't going to give
you. The FBI has a policy that they do not give it to private attorneys. Thank you. Okay.
Did you take the necessary steps that the prosecutor says you didn't do? Just making two
phone
calls?
Well, we're going to do it again. The FBI does not give to private attorneys. And you heard what Mr. Asher said in there. Well, they'll send it to them and then send it to us. Normally, and I've been in a lot of cases across the country, the prosecutors just say, please give me your notes, and they give it. So it's a process of cooperation. If they want to put us through these hoops, we'll go through the hoops. But ultimately, we're going to get the notes, and ultimately, it's going to hurt them by objecting or not taking the necessary steps, because you'll hear me at trial going to ask, did the prosecutor ever ask you for your notes? And guess what the answer is going to be? No. So if the prosecution wants to take that risk, please, we love it.
Are you going to follow up on the fact that the crime scene investigators for the sheriff's office destroyed their notes after they put them in the report?
I can give you a one-word answer. Yes.
What do you plan to do?
You'll see at trial.
Judges don't know how to recognize junk science from real science. We intend to use this report to educate the judge in this case.